सो हेलो एवरीवन, माय नेम इज़ प्रीतम एंड आज जो है हम कंटिन्यू करेंगे ए आई बी ई नाइन्थ का जो प्रीवियस ईयर क्वेश्चन पेपर हम ऑलरेडी सॉल्व कर रहे थे। तो हमने 1 to 50 ऑलरेडी जो क्वेश्चंस है वो पार्ट 1 में सॉल्व कर लिया है और ये सेकंड पार्ट रहेगा और ये लास्ट है। दो पार्ट में बेसिकली ये वीडियो में जो है अपलोड करूँगा। फर्स्ट ऑलरेडी मैंने अपलोड कर दिया जिसमें क्वेश्चन नंबर 1 to 50 है और ये जो है ये 51 to 100 जाएगा, ठीक है। और इसके जो आंसर्स किए हैं मैंने साइड में ओपन किए हुए हैं, तो इसमें से मैं जो है करेक्शंस अगर होंगे तो वो मैं इन्फॉर्म करता रहूँगा। एक सेकेंड, पेज कहाँ चला गया? पेज एक सेकेंड देख लो मैं। ठीक है, सो इसमें रहेगा हमारा क्वेश्चन नंबर 51 to 100। मैं रीड करता रहूँगा, साथ में जो इसके जो आंसर्स हैं वो भी टिक लगाता रहूँगा, क्योंकि मुझे भी रिवीजन करनी है। जितने भी प्रीवियस क्वेश्चन पेपर हैं तो उसकी रिवीजन करनी थी, तो मैंने सोचा साथ में आपको भी इंक्लूड कर लूँ और आप जो है चेक कर सकते हैं। और इन केस अगर ऑलरेडी आपको आता है तो इसकी रिक्वायरमेंट नहीं है। और वीडियो की स्पीड अगर स्लो लग रही हो तो आप अपने अकॉर्डिंग एडजस्ट कर लेना, उसको फास्ट कर लेना, अपना टाइम सेव करना अपने अकॉर्डिंग, ठीक है। क्वेश्चन नंबर 51 जो है वो कहता है वेयर द पुलिस submits a final report under section 173 subsection 2 of CRPC for dropping of proceedings to a magistrate. The magistrate, option से हमारे पास may accept the same, B may reject the same, option C may reject the same and order further investigation, option D any of the above। 51 का राइट आंसर है ऑप्शन डी विच इज एनी ऑफ द अबव। क्वेश्चन नंबर 52, the orders under section 125 of CRPC are option A summary in nature but finally determine the rights and obligation of the party, option B summary in nature and do not finally determine the rights and obligation of the parties which are to be finally determined by a civil court, option C substantive in nature and finally determine the rights option C substantive in nature and finally determine the rights and obligations of the parties, option D substantive in nature and are not subject to determination of a right of the parties by a civil court। 52 का जो राइट आंसर है वो है ऑप्शन बी which is summary in nature and do not finally determine the rights and obligations of the parties which are to be finally determined by a civil court। Question number 53, a contingent contract based on the specified uncertain events not happening within a fixed time under section 35, options है option A remains valid even if the event does not happen within that fixed time, option B becomes void at the expiration of the time fixed, option C become void if the happening of that event becomes impossible before the expiry of time fixed, option D both B and C। So 53 का right answer है option D which is both B and C। Question number 54, which among the following is authorized under the Information Technology Act 2000 to prescribe the security procedures and practices for the purpose of section 14 and 15 of the act? Options हमारे पास सेंट्रल गवर्नमेंट, ऑप्शन बी स्टेट गवर्नमेंट, ऑप्शन सी सर्टिफाइंग अथॉरिटी, ऑप्शन डी इशूइंग अथॉरिटी। 54 का राइट आंसर ऑप्शन ए विच इज सेंट्रल गवर्नमेंट। क्वेश्चन नंबर 55, the essential ingredient of the tort of negligence are: first, when one owes a duty of care towards the other; Second, when one commits a breach of the duty, and third, the other person suffers damage as a consequences thereof. आई एम सॉरी, कोई आ गया था तो मुझे वीडियो पॉज करना पड़ा, इसको कंटिन्यू रखते हैं। तो 52 आई थिंक हो गया था, 54 भी हो गया है एज आई कैन सी। 55 से स्टार्ट करते हैं। 55 कहता है द एसेंशियल इंग्रेडिएंट ऑफ द टॉर्ट ऑफ नेग्लिजेंस आर। सॉरी, आई थिंक मैं इसको ऑलरेडी मैंने हाफ कर दिया था, तो स्किप कर लीजिएगा प्लीज। सो रिपीट कर देता हूँ। क्वेश्चन नंबर 55, द एसेंशियल इंग्रेडिएंट ऑफ द टोट ऑफ नेग्लिजेंस आर: फर्स्ट, व्हेन वन ओज अ ड्यूटी ऑफ केयर टुवर्ड्स द अदर; सेकंड, व्हेन वन commits a breach of that duty; and third, the other person suffers damage as a consequence thereof. Choose correct response for below. Options हमारे पास ऑप्शन ए, none of them are essential ingredients; ऑप्शन बी, only the first is an essential ingredient; C, all of them are essential ingredients; D, even if the first is absent the tort of negligence is committed. 55 का राइट आंसर ऑप्शन सी, which is all of them are essential ingredient. 55. 55 says vicarious liability includes, ऑप्शन से हमारे पास ऑप्शन ए, liability of the principal for the tort of his agent; ऑप्शन बी, liability of the master for the tort of his servant; ऑप्शन सी, liability of the partners for each other's tort; ऑप्शन डी, all of the above. 56 का राइट आंसर ऑप्शन डी, which is all of the above. क्वेश्चन नंबर 57, necessity rules as to admissibility of the evidence is applicable when the maker of a statement, ऑप्शन से हमारे पास ऑप्शन ए, is dead or has become incapable of giving evidence; ऑप्शन बी, is a person who can be found but his attendance cannot be procured without unreasonable delay or expenses; option C, is a person who cannot be found; option D, all of the above. 57 का राइट आंसर ऑप्शन डी, which is all of the above. क्वेश्चन नंबर 58, secondary evidence of a document means, option A, copies of the document; option B, oral account of the contents of the documents; option C, both A and B; option D, none of the above. 58 का राइट आंसर ऑप्शन सी, which is both A and B. Question number 59, a will is required by the uh, a will is required to be proved by calling at least one attesting witness; ऑप्शन हमारे पास ऑप्शन ए, when it is registered; ऑप्शन बी, when it is unregistered; ऑप्शन सी, when it is admitted; ऑप्शन डी, all of the above. 59 का राइट आंसर ऑप्शन डी, which is all of the above. Question number 60. Any person in section 106 of Evidence Act refers to, option A, a party to the suit; option B, a stranger to the suit; option C, a person who is not a party to the suit but interested in the outcome of the suit; option D, all of the above. 60 का right answer option A, which is a party to the suit. Question number 61. In a cognizable case under IPC, police have to, ऑप्शन हमारे पास ऑप्शन ए, ऑथोरिटी टू अरेस्ट अ पर्सन विदाउट वारंट; ऑप्शन बी, ऑथोरिटी टू इन्वेस्टिगेट ऑफेंस विदाउट परमिशन ऑफ द मैजिस्ट्रेट; ऑप्शन सी, बोथ ए एंड बी; ऑप्शन डी, इधर ए और बी. 61 का राइट आंसर है ऑप्शन सी, विच इज बोथ ए एंड बी. क्वेश्चन नंबर 62, ड्यूरिंग इन्वेस्टिगेशन अ सर्च कैन बी कंडक्टेड विदाउट वारंट बाय, ऑप्शन ए, एनी पुलिस ऑफिसर; बी, by the investigating officer; option C, both A and B; option D, either A or B. 62 का right answer है option C, which is both A and B. Question number 63, committal proceedings under section 209 of CRPC are in the nature of, option A, aid in investigation; option B, inquiry; option C, trial; option D, either inquiry or trial. 63 का right answer option B, which is inquiry. Question number 64, which is correct? Option A, proposal plus acceptance equal to promise; option B, promise plus consideration equal to agreement; option C, agreement plus enforceability equal to contract; option D, all of the above. 64 का right answer है option D, which is all of the above. Question number, proposal plus acceptance becomes promise; promise plus consideration become agreement. ठीक है. क्वेश्चन नंबर 65, communication of acceptance is complete as against the proposer. ऑप्शन से हमारे पास ऑप्शन ए, when it comes to the knowledge of the proposer; ऑप्शन बी, when it is put in course of transmission to him so as to be out of power of the acceptor; ऑप्शन सी, when the acceptance is communicated to the proposer, option D all of the above. Question number 65 का right answer option B, which is when it is put in course of transmission to him so as to be out of power of the acceptor. Question number 66. In cases of general offer for a valid contract, options है हमारे पास. क्वेश्चन फिर से रिपीट कर देता हूँ. In cases of general offer for a valid contract, options are option A, the acceptor need to have the knowledge of the offer. Option B, the acceptor must have the knowledge of the offer before acceptance by performance. Option C, the acceptor may acquire the knowledge of the offer after the performance of the condition for acceptance. Option D, knowledge does not matter so long as the condition is performed with or without knowledge. 66 का right answer है option B, which is the acceptor must have the knowledge of the offer before acceptance by performance. Question number 67. Under the provision of the Transfer of Property Act 1882, the unborn person acquires vested interest on transfer for his benefit. Options are option A, upon his birth, option B, 7 days after his birth, option C, 12 days after his birth, option D, no such provision is made. 67 का right answer है option A, which is upon his birth. Question number 68. Every transfer of immovable property made with intent to defeat or delay the creators of the transfer shall be voidable. Options are at the opinion, option A, at the opinion of creditor so defected or delayed, option B, at the option of debtor, option C, at the option of court, option D, none of the above. 68 का right answer option A, which is at the opinion of creditor so defeated or delayed. Question number 69. Where a co-judgment debtor are in the position of joint promisors, each is option A, not jointly and severally liable to the decree holder, option B, jointly and severally liable to the decree holder, option C, jointly liable to the decree holder only, option D, severally liable to the decree holder only. 69 का right answer है option B, which is jointly and severally liable to the decree holder. Question number 70. At site under section 21 of Negotiable Instruments Act 1881 means option A, on presentation, option B, on demand, option C, on coming into vision, option D, none of the above. 70 का right answer option B, which is on demand. Question number 71. Section 5 of the Limitation Act applies to option A, suits, option B, execution, option C, election petition, option D, none of the above. 71 का right option है option D, which is none of the above. Question number 72. Which of the following companies will have to constitute corporate social responsibility committee under the Companies Act 2013? Options हमारे पास option A, a company have a net profit of 2.5 crore in a fiscal year, a net worth of 300 crores and a turnover of rupees 800 crore. Option B, a company having a net profit of 3 crores in a financial year, a net worth of 300 crores and a turnover of rupees 600 crore. Option C, a company having a net profit of 5 crore or more, a net worth of 500 crore and a turnover of rupees 1000 crore or more. Option D, a company having a net profit of 5 crore or more, a net worth of 500 crore and a turnover of rupees 5000 crore or more. 72 का right answer है option C, which is a company having a net profit of 5 crore or more, a net worth of 5 crores and a turnover of rupees 1000 crore or more. Question number 73. A disqualified person here, option है हमारे पास, a disqualified person or here, option है हमारे पास option A, transmits an interest to his or her own heir, option B, transmit no interest to his or her own heir, option C, may or may not transmit an interest to his or her own heir as per the discretion of the court, option D, may only transmit an interest to his or her own heir with the consent of the other heirs. 73 का right answer है option 73 का right answer option B, which is transmits no interest to his or her own heir. Question number 70 and 74. In cases in which a specific act confers a discretionary power on an authority ऑप्शन हमारे पास ऑप्शन ए, द कोर्ट कैन डायरेक्ट द मैनर इन विच द power is exercised. Option B, the court can direct that the power be exercised in accordance with law. Option C, both A and B. Option D, neither A nor B. And the right option for the question number 74 is option C, which is both A and B. Question number 75. The Bar Council of India rule which stipulated that persons aged 45 years and above could not be enrolled as advocates was struck down by the Supreme Court in which case? ठीक है, options are option A, in E.S. Reddy versus Bar Council of India. Option B, Indian Council of Legal Aid and Advice versus Bar Council of India. Option C, P, Sun Mungam versus Bar Council of India. Option D, Legal Committee versus Bar Council of India. 75. Right answer for 75 is option C, which is P, Sanmungam, P, Shanmungam versus Bar Council of India. And you should learn this judgment because uh, it's reflecting a landmark topic, which is allowing a person to enroll after the year of 45 years. So it becomes important in itself, so we have to remind this judgment, okay, which is P Sangmungam versus Bar Council of India. Question number 76. Which is an incorrect statement? Options are option A, an arbitral award is a contract. Option B, an arbitral award must be in writing and signed. Option C, an arbitral award included an interim award. Option D, none of the above. And the right option is option A, which is an arbitral award is a contract. An arbitral award is a contract. Question number 77. Which of the following statements hold true for adjudicatory bodies? Options are option A, doctrine of share decisis applies to them. Option B, doctrine of res judicata does not apply to them. Option C, inherent lack of jurisdiction in a tribunal cannot be cured or created by the act of the parties. Option D, none of the above. Right option is option C, which is inherent lack of jurisdiction in a tribunal cannot be cured or created by the act of the parties. Question number 78. The Supreme Court held in VC Rangadurai versus D. Gopalan, an advocate who has been disbarred or suspended from the practice must prove after expiration of a reasonable length of time that options A, he appreciated the insignificance of his dereliction. Option B, he has lived a consistent life of poverty and integrity. Option C, he possesses the good character necessary to guarantee uprightness and honor in his professional dealings. Option D, the burden is on the applicant to establish that he entitled to resume the privilege of practicing law without restrictions. And the options are option C, which is he possesses the good character necessary to guarantee uprightness and honor in his professional dealings. Question number 79. The present Arbitration and Conciliation Act of 1996 is based on option A, Constitution of India. Option B, Supreme Court of India guidelines. Option C, European Commercial Arbitration Procedure. Option D, UNCITRAL, which is UNCITRAL. And the right option is option D, which is UNICITRAL. Question number 80. Who among the following is authorized to issue regulations regarding self prospectus? Options are SEBI. Option B, Central Government. Option C, Company Law Board. Option D, National Company Law Tribunal. Right answer is option A, which is SEBI. Question number 81. Which of the following is not included in the definition of cattle as given under the Indian Forest Act 1927? Options are option A, rams. Option B, kits. Option C, kitten. Option D, none of these. Right option is option C, which is kitten. Question number 82. The provisions of the Arbitration and Conciliation Act of 1996 have to be interpreted being uninfluenced by the principles underlying the 1940 Act. This observation was laid down in option A, MMTC Limited versus Sterlite Industries India Limited. Option B, Sun Dream Finance Limited versus NEPC Limited. Option C, Olympus Olympus Superstructures was Private Limited versus Mira Vijay. Option D, Orma Impacts Private Limited versus Nisari Private Limited. And the right option for the question number 82 is option B, which is Sundaram Finance Limited versus NEPC Limited. Question number 83. Which of the following services cannot be provided to the company by an auditor appointed under the provision of the Companies Act 2013? Options are option A, internal audit, option B, actuarial, I don't know ये क्या होता है, actuarial, actuarial services, option C, managerial services, option D, all of these. And the right option is option D, which is all of these. ठीक है, ऑलरेडी 83 तक हमने कर लिया है और 16 क्वेश्चंस और रह गए हैं, तो इसको भी अभी कर लेते हैं हम. मैं इतने थोड़ा पानी पी लूं, बोलते बोलते गला सूख जाता है. ठीक है, कंटिन्यू करें. Question number 84. Under the Wildlife Protection Act 1972, any person who teases an animal in a zoo may be punished. Option A, with fine may extend to 5,000. Option B, with imprisonment which may extend to up to 1 year. Option C, both A and B. Option D, neither A or B. 84 का right answer option D, which is neither A nor B. Question number 85. The entry on forest and protection of wild animals and birds was moved from dash to the dash by the 42nd Amendment of the 42nd Amendment to the Constitution of India. Options are option A, central list to state list, option B, central list to concurrent list, option C, state list to concurrent list, option D, state list to union list. And the right option is option C, state list to concurrent list. Question number 86. Broit des Gens Law of Nations 1758 was written by option A, Cornelius van Binkershoek. Cornelius van Binkershoek. Option B, Emmerich de Wattel. Option C, Richard Zauch. Option D, Jean Bodin. So if pronunciation करेक्ट ना हो तो प्लीज़ माइंड मत कीजिएगा. और इसका जो राइट ऑप्शन है हमारे पास वो है ऑप्शन बी, विच इज़ एमरिच डे बैटल. Question number 87. To establish section 34, option A, common intention must be proved but not overt act is required to be proved. Option B, common intention and overt act both are required to be proved. Option C, common intention need not be proved but only overt act is required to be proved. Option D, all of the above. 87 का right answer है option A, which is a common intention. ये क्या हुआ, एक सेकेंड, कोई नहीं. राइट ऑप्शन है इसका 87 का ए, which is a common intention must be proved but not overt act is required to be proved. Question number 88. Under the provisions of the Industrial Disputes Act 1947, the appropriate government can By order in writing, option A, refer the dispute to a board for promoting a settlement of the dispute. Option B, refer any matter appearing to be relevant to the dispute to a court for inquiry. Option C, both A and B. And option D, neither A nor B. 88 का राइट आंसर है ऑप्शन सी, विच इज बोथ ए एंड बी। Question number 89. Which of the following statement is true for loss of confidence by management in the workman? Options are option A. Even when dismissal or discharge is held to be wrongful, the court may not yet order reinstatement if the employer is able to establish that the workman held a position of trust and there was loss of confidence. Option B. Loss of confidence may also be a ground for discharge, simply seater of the workman. Option C, both A and B. Option D, neither A nor B. 89 का राइट आंसर है ऑप्शन सी, विच इज बोथ ए एंड बी। Question on 90. Under the provisions of the Consumer Protection Act 1986, the period of limitation for filing complaint before the National Commission is option A, 1 year from the date on which cause of action has been arisen. Option B, 2 years from the date on which cause of action has arisen. Option C, 3 years. Option D, 4 years. So 1, 2, 3, 4 from the date of cause of action has been arisen, and the right option is for the question number 90 is option B, 2 years. So 2 साल का हमें लिमिटेशन देखने को मिलेगा, कब से? कॉज ऑफ एक्शन जब से अराइज होता है तब से। सो इन केस अगर कॉज ऑफ एक्शन, मान लीजिए आपने कोई चीज़, आपने एक एसी परचेज किया है 2021 में, ठीक है, और इसकी वारंटी जो है 2021 में आपने इसको परचेज किया, इसकी वारंटी चलती है 2023 तक। अब 2023 तक ये वारंटी पीरियड में है, ये जो एसी वारंटी पीरियड में है, और ख़राब हो जाता है इन केस 2 साल बाद ख़राब हो जाता है। चलो इसको 24 मान लो कि 4 साल बाद ये ख़राब हो जाता है। आपने 2021 में एसी परचेज किया और 2024 में ख़राब हो गया, बट फॉर्चुनेटली ये जो है वारंटी पीरियड में है, 3 साल की वारंटी मिली थी, तो ये लास्ट ईयर है उस वारंटी का और वारंटी पीरियड में है। तो जब आप कंप्लेन करते हो कि वो एसी आपका ख़राब हो गया है और वारंटी पीरियड में है, तो इन केस अगर आपको जो कंपनी है वो डिनाई कर देती है कि नहीं, हम आपको जो है वारंटी पीरियड में इंक्लूड नहीं करेंगे क्योंकि हमारी न्यू पॉलिसी आई है और 2024 से हमने 2 साल की वारंटी रख दी है, तो पहले 3 की थी और अब क्योंकि हमारी नई पॉलिसी आई तो हमने चेंज कर दिया है। तो उन, मान लो ऐसा कुछ बोलती है और आपको जो क्लेम है आप नहीं वो क्लेम ले पाते हो, तो ऐसे में कॉज ऑफ एक्शन का जो डेट है वो 2024 पड़ेगा। 2024 में जिस भी दिन आपने बात किया होगा कॉल पे, तो वो हो जाएगा आपका कॉज ऑफ एक्शन का डेट, और इस 2024 से लेके 2026 तक आप कंप्लेन कर सकते हो, ठीक है। ऐसा नहीं है कि 2021 में आपने परचेज किया तो 2023 तक 2 साल ये मानोगे। जब कॉज ऑफ एक्शन अराइज होगा, मान लीजिए 2024 को आपने बात की और उन्होंने डिनाई कर दिया कि नहीं हम आपके जो है इसी को सर्विस प्रोवाइड नहीं कर पाएंगे, तो यहाँ से इस 2024 से लेकर 2026 तक जो कि 2 साल होगा, 2 years होगा, इसको हम मानेंगे ये लिमिटेशन होगा। 2026 के बाद 2024 में कॉज ऑफ एक्शन अराइज हुआ, 2026 तक आप कंप्लेन कर सकते थे कंज्यूमर कोर्ट में, और 2026 के बाद आप नहीं कर पाएंगे क्योंकि लिमिटेशंस की वजह से वो बाउंडेशंस क्रिएट हो जाती है। Question number 91. Grievous hurt under the Motor Vehicles Act 1988 means option A, grievous hurt as defined in IPC. Option B, grievous hurt as defined in medical laws. Option C, grievous hurt as detected by medical practitioner. Option D, none of the above. 91 का राइट ऑप्शन है ऑप्शन नंबर ए, विच इज ग्रीवियस हर्ट एज डिफाइंड इन आईपीसी। क्वेश्चन नंबर 92. Retracted confession. Options are option A, can be solely made the basis of conviction. Option B, cannot be solely made the basis of conviction. Option C, cannot be solely made the basis of conviction unless the same is corroborated. Option D, both A and C are correct. 92 का राइट ऑप्शन है ऑप्शन सी, कैनॉट बी सोली मेड द बेसिस ऑफ कन्विक्शन अनलेस द सेम इज corroborated. क्वेश्चन नंबर 93, a confession to be inadmissible under section 25 of the act. ऑप्शन है ऑप्शन ए, must relate to the same crime for which offender is charged. ऑप्शन बी, may relate to the same crime for which offender is charged. ऑप्शन सी, must relate to another crime. ऑप्शन डी, none of the above. And 93 का राइट आंसर ऑप्शन सी, which is must relate to another crime. Question number 94, an unjustified and unexplained long delay on the part of the investigating officer in recording the statement of material witness would render the evidence of such witness. Options are option A, unreliable, option B, unadmissible, option C, inadmissible and unreliable, option D, none of the above. And the right option is option A, which is unreliable. Question number 95, recording of the pre-summoning evidence may be dispensed with under section 200 of CRPC. Options are option A, if the complaint is supported by the affidavit of the complainant. Option B, if the complaint is made in writing by a public servant in the discharge of his official duties. Option C, both A and B are correct. Option D, only A is correct but B is incorrect. And the right option is option B, which is if the complaint is made in writing by a public servant in the discharge of his official duties. Question number 96, contract without consideration made in writing and registered and made on account of natural love and affection is option A, void, option B, reasonable, option C, valid, option D, unenforceable. 96 का right option है option C, which is valid. Question number 97, under the Transfer of Property Act, question number 97, under the Transfer of Property Act 8082, option A, the salary of a public officer can be transferred. Option B, the salary of a public officer cannot be transferred. Option C, public office can be transferred. Option D, none of the above. 97 का right answer option B, which is the salary of a public officer cannot be transferred. Question number 98, where a debt is transferred for the purpose of securing an existing or future debt, the debt so transferred, if received by the transferor or recovered by the transferee, is applicable first in payment of cost of such recovery. This is the provision of option A, mortgage debt, option B, gift, option C, ex-naval claim, option D, lease. And the right option is option number A, which is mortgage debt. Question number 99, a suit under section, एक सेकेंड, question number 99, a suit under section 6 of the Specific Relief Act can be brought by option A, trespasser, option B, a tenant holding over, option C, servant, option D, manager. 99 का right answer option B, which is a tenant holding over. Question number 100, injunction cannot be granted in a suit. Option A, in which the specific performance cannot be enforced. Option B, for breach of negative contract to enforce a specific contract. Option C, for declaration where the plaintiff is in possession. Option D, neither A nor B nor C. And the right option is option A, which is in which the specific performance cannot be enforced. So 1 to 50 हमने ऑलरेडी कर लिया था, अब 51 to 100 हमने कर लिया है, और इसी के साथ AIB 9 का जो प्रीवियस ईयर क्वेश्चन पेपर था वो हमने ऑलरेडी सॉल्व अभी तक कर लिया है. इसके बाद हम AIBE 10 का जो प्रीवियस ईयर क्वेश्चन पेपर है हम उसको पिक करेंगे और उसको सॉल्व करेंगे. होगा क्या कि अगर आपको क्वेश्चन आता है तो आपकी रिवीजन हो जाएगी, नहीं आता है तो आपको याद हो जाएगा, आपका इसको जो AIB का जो पैटर्न है वो आपके माइंड में आ जाएगा. तो कहीं ना कहीं आपको इसका जो है बेनिफिट है वो तो मिलेगा ही. इन केस अगर आपको आता है ऑलरेडी तो फिर तो रिक्वायरमेंट नहीं है आपके लिए, आप उसकी जगह कुछ और भी पढ़ सकते हो. तो अभी तक के लिए इतना ही. नेक्स्ट वीडियो में मिलेंगे, AIB 10 को सॉल्व करेंगे 1 to 50. और इस वीडियो में हमने कहाँ से कहाँ तक सॉल्व किया, 51 से 100 तक सॉल्व किया इस वीडियो में. इससे पहले का कहाँ था, इससे पहले का जो 1 to 50 जो है वो मैंने एक पार्ट 1 करके AIB 9 का पार्ट 1 करके मैंने वीडियो अपलोड कर दिए है, और ये जो है ये जाएगा पार्ट 2, AIB 9 का प्रीवियस ईयर क्वेश्चन पेपर पार्ट 2, विच इज़ फ्रॉम क्वेश्चन नंबर 51 to 100. सो तब तक के लिए आप सभी का धन्यवाद.